Good morning, everyone. Good morning, and thank you for joining us so early this morning for our initial reactions to the Supreme Court's decision in Sequana and BTI, handed down yesterday, some 17 months, I think it's almost to the day, following the hearing. This is a forerunner talk to the more detailed analysis that Chris is going to present at our annual restructuring and insolvency conference on the 8th of November. So please do sign up for that as well. Email events@radcliffechambers.com and we'll get you on the list. The headline point first from the Supreme Court's decision is that the creditor's interest duty exists. They were at least unanimous as to that, even if they couldn't decide between themselves what to call it. And that divergence of view, even on that minor point, illustrates that the court did not speak with one voice, even though it was agreed on the result. The majority judgment was given by Lord Briggs, with whom Lord Kitchen agreed. There was a concurring judgment from Lord Hodge, and Lord Reid and Lady Arden concurred in the result, but for different reasons. They didn't agree with Lord Justice David Richards, as he then was, which might make for interesting moments around the coffee machine, as he is now a Supreme Court Justice. Just to give you a flavour of the length of the judgments, Lord Reid's judgment is paragraph 1 to 111. Lord Briggs is 112 to 206. Lord Hodges 207 to 247. And then there is a mammoth judgment from Lady Arden at the back of the judgments, 248 to 451. And her judgment takes up some 75 pages of the PDF that came straight from the court yesterday. It's obvious that this decision deals with questions of considerable importance and has significant practical implications, especially as we move to a time where there is, at least it seems to me, a likelihood of more corporate failure. It's even more important that we can advise directors what they should do and as to their personal liabilities. And it's useful as we look through the judgments to see what's not dealt with and whether it does impact on the question whether the court has in fact given guidance to directors. And Chris, I was going to just let you come in with your initial views and then I was going to do a quick run through the facts before we get into the 4 points we wanted to raise.
Sure, yeah, let's start off just by looking at what they agreed in a little bit more detail, but also move on to emphasize what they didn't agree on. I mean, in a measure of the level, it seems, of debate that was before the court, the Supreme Court members couldn't actually agree on what the duty was called. Lord Briggs, Lord Kitchen and Lord Hodge were happy to adopt what I think has now sort of passed into common usage, the term, the creditor interest duty. Lords Reeds and Arden were not willing, even in the judgment, to call it that. And they insisted on calling it the West Mercia duty. And the reason Lord Reid gave for that was that he wanted to ensure that, that people understood that it was a duty that was owed to the company, not to creditors. And we know there are lots of judgments in the past where judges sort of adopt the creditors, you know, the sort of phrase duty to creditors, even though what they really mean is a duty to the company, and everyone knows that, but that sort of slips out from time to time. And the other thing he wanted to do was to emphasize that it wasn't a duty that's owed in its own right. So there's no duty to look after the interests of the creditors as such. It's simply part of a duty, another duty. namely the duty in section 172 of the Companies Act, subsection referred to specifically in subsection 3. And that, of course, that's the duty to promote the success of the company. So it's a qualification on what would otherwise be the duty that's set out in section 172(1). But I think it's easier just to use the creditor interest duty, and I think that's actually what's going to happen. That's going to be now used. So the 5 members of the court were able to agree on, it seems to me, on the following. First of all, as David said, that there was such a duty. It seems extraordinary that they had to do that, given that there's a case called Bilter where the Supreme Court already did recognise that duty. But the BTI in this case were arguing that, in fact, there was no such duty. Sorry, Sequana were arguing that there was no such duty, Mr. Rabinowicz. And so the court had to address that particular point, but they were all able to agree that there was such a rule. Secondly, they were able to agree that it didn't arise merely when there was a real prospect of insolvency. And that's really, they said, as far as they needed to go in this case. But they did go further. You may think obiter, but they did go further, and they were able to agree that the duty arose either when the company was actually or imminently insolvent, or when there was a probability of insolvent liquidation or administration. That is now the trigger that they all accepted would give rise to the duty. And they were also able to agree that the duty arose not only generally, but in particular, when directors decided to declare a dividend, notwithstanding the specific provisions in the Companies Act that dealt with the circumstances in which a dividend would be lawful. So but that's as far as it went, really. The majority went on to hold that the duty would arise when the director knew or ought to know that the trigger was reached. So that's the knowledge point, which I think is important. Only the majority were willing to go that far. Secondly, they were able to acknowledge that the effect of the duty, or the scope of it, what it actually required the director to do, was to take into account and to give appropriate weight on the facts of each case to the interests of the creditors as a body. That's important. I would call that, I call that the sort of sliding scale, as it were, as opposed to a cliff edge, which perhaps had been indicated in the Court of Appeal, where and earlier cases where once the duty is triggered, you just have to act in the interests of creditors, or they're paramount. That was another way that was often described. Thirdly, the majority were able to recognise that once liquidation or administration was inevitable, there was at that stage, but at that stage only, a requirement to act in the interests of creditors. That's where this paramountcy point comes in. It now comes in only where the insolvent liquidation is inevitable. So that's the point at which the section 214 duty is triggered. And then they were also able to agree that the duty was to be interpreted and developed in due course in such a way as to complement the other provisions of the Companies Act and the Insolvency Act, and in particular, the sort of dovetailing that I've just indicated with section 214, which is something I think new and nobody had really explored much before, but it formed part of the arguments that the court held. In particular, Sequana and Mr. Rabinowicz were arguing that there was no need for the creditor's interest duty because statute had already provided protection to creditors. And so it was held that one interprets and will develop this duty in accordance with, with the parameters of the statutory provisions. And finally, it seems to me there is a recognition that the effect of the duty is to modify the ordinary situation, which applies under section 172(1), namely to act in the interests of the shareholders. So it operates within that framework, but there's still uncertainty, it seems to me, as to the extent to which this duty would equally apply to the other duties in that part of the Companies Act, so section 171 to 77 in particular, when, for example, the duty to exercise reasonable care and skill. You know, in what circumstances do you need to consider the creditor's duty in that respect? And we know that in that particular area, it's necessary to do that. Section 214 is a classic expression of that. So that's what the majority held. And the minority, it seemed to question a number of those points and express slightly different opinions. Headline points would be Lord Reid's questioning as to the level of knowledge that would be required, and Lady Arden sort of chiming in on that, whether in fact there was any requirement for the director to know or ought to know that the company was insolvent or on the brink of insolvency, because their view was that the director should really know that anyway. And Lady Arden sort of expressed it in a sort of negative way, saying, well, the burden would be on the director to prove that he didn't know. Although how that would work, she didn't really explain. Another thing was that it's sort of endorsing of the line of authority where preferences, for example, were granted, and endorsing the specific application of the duty to those sort of situations, building on sort of West Mercia, and the approval by Lords Reid and Arden of the outcome of that cases and the remedies that were available in those cases, even though there wasn't an increase in the net deficiency, so no balance sheet difference to the company and no loss in that sense to the company. And their insistence really, I think, in ensuring that they were expressing no more than sort of provisional views, as they put it, on various matters, leaving it to be developed in a rather, you might think, unsatisfactory way, because if they were emphasizing that they didn't actually need to go very far in this particular case, and they were only expressing sort of provisional views, well, how would that really assist in what everyone acknowledged was a very important role that they were playing, which is to give direction and certainty to directors in the future? And it's very questionable, it seems to me, and I agree with David, whether or not they really managed to achieve that in this case. Anyway, that's my sort of 5-point, as it were, summary of where we've got to.
Yeah, absolutely, Chris. Thanks for that. And I agree that there are some throwaway comments that aren't helpful. And Lady Arden observes that some of this will have to be worked out in due course, because that's how the common law develops. And she's right, of course, about that. But it doesn't help in us advising directors or bringing or defending claims against directors, because it tends away from certainty rather than towards it. And I think in terms of practical implications, that's one of the biggest ones. The Supreme Court perhaps hasn't given as much certainty as might have been hoped, having kept us waiting for 17 months for the answer. I thought I'd very quickly, I've got an eye on the time, just very quickly canter through the facts. And then we look at 4 points, Chris, if that's all right with you.
Yeah.
The facts, in case you haven't had a chance to go back to them, which has been a long time since you've looked at this, is about a dividend declared by a company called AWA at a time when it was plainly solvent on both the balance sheet and commercial bases. There was a real risk that it might become insolvent in the future, and that was because it had contingent liabilities for cleaning up long-term pollution. But insolvency was neither imminent nor even probable. And so it declares its dividend, and 10 years later it goes into insolvent administration. BTI is the assignee of AWA's claims against its directors in respect of the decision to distribute the dividend. And so they sue the directors for breach of the creditor duty, saying that the directors had failed to consider or act in the interest of AWA's creditors. And they fail at both first instance and in the Court of Appeal. And the judgment of the Court of Appeal is essentially that the creditor duty doesn't arise until the company is either actually insolvent or on the brink of insolvency or probably headed for insolvency. And as Chris has said, the provisional view expressed by Lord Justice David Richards was that the creditor duty became paramount, that's the cliff edge that Chris was talking about, as soon as the company became insolvent. And because when AWA declared its dividend, it was neither insolvent nor on the brink, the creditor's duty claim failed. That was the appeal then that BTI took to the Supreme Court, and we run you through very briefly the decision. There are 4 points that we'd like to raise by way of immediate reaction, and we've touched on some of these already. The first is the trigger. We might spend a few minutes just talking a little bit more about that. Then we have the scope, or what's called the content of the duty once it's triggered. We think it's important to pick up on the observation in the judgment that the duty is owed to the creditors as a body, and what that might mean, and then to think briefly about the practical implications that the judgment might have as we move forward. I think it's right, Chris, to say, isn't it, that the trigger is now somewhat later on Lord Briggs's formulation than it was in the Court of Appeal. But I'm not sure it's as simple as that. I don't know whether you want to talk through where there are different triggers for different types of duty.
Yeah, the way I put it, the dial has moved back towards the insolvency date from where it was before. I think that's the big headline here. And the thing that, and that was going to be welcomed obviously by directors, because the effect of the Court of Appeal decision was to, I think, reach a conclusion that the duty arose earlier than people had previously understood the position to be the case. In the earlier cases, all the judges had always talked about insolvency or the verge of insolvency. And so people, I think, were slightly surprised to discover that actually the duty arose whenever there was a probability of insolvency, because that's what the conclusion of the Court of Appeal was. And in fact, Lord Briggs described David Richards' analysis of the case law, I think, as magisterial in his judgment. That was the sort of the nice thing he said before he disagreed with David Richards and the Court of Appeal, because after concluding this magisterial analysis, David Richards had come up with a sort of 4 different possibilities for trigger points in the Court of Appeal. The first one was when there's actual insolvency. Secondly, when there's dubious insolvency, so that's the verge of, the various different types of words used in the cases. Thirdly, the likely insolvency. And fourthly, the real risk of insolvency, which was what was being argued by BTI and Andrew Thompson. And he went for the third one, the likely insolvency, which he said involved a probability. So on the balance of probabilities, the company would be insolvent. And he reasoned in the Court of Appeal that was because he thought the second option was a bit vague. And he thought that the real risk of insolvency option would have a chilling effect, I think was his words, on sort of commercial activity. And so he plumped for the likely insolvency test. And he formulated that as being where the director knows or ought to know that the company is likely to become insolvent. And Lord Justices Henderson and Longmore agreed with him. One of the great things, I think, about the Court of Appeal judgment is that there was only one of them, as we've now discovered. That's a real benefit when people are trying to analyse what duties of directors are. We're in an unfortunate position now where there are several judgments, and at the very least they have a different emphasis. And in fact, as we'll discuss, some of them have different content as well. So the majority, well, one thing they were all unanimous on is that they all disagreed with the Court of Appeal. And they all managed to agree, I think, the reason why they disagreed with the Court of Appeal was because it paid insufficient attention to the justification for the duty. And previously, the courts have always analysed this or looked at creditors as having a sort of quasi-proprietorial interest in the company. And Lord Briggs in particular looked at the sort of different justifications. So he analysed them into three sort of categories. But in the end, he came up with what he described as a sort of an economic interest theory. And I think that that's one which all of them subscribe to in the end. But the critical point here is that the reason why creditors have an economic interest in the company is because when the company is wound up, they share in the proceeds of the realizations through the mechanisms in the Insolvency Act. But he stressed, Lord Briggs, that it wasn't until the company was wound up that they had that interest. And that was the justification for, as it were, dialing back the duty from where the Court of Appeal said it was to where the Supreme Court have now held it to be. And he in particular said that the shareholders have the main economic interest in the company. And whilst the company is solvent, so in that area prior to solvency, they have the main economic interest. And also he said, while there was still light at the end of the tunnel, that sort of section 214 stroke easy, easy air, Lord Neuberger type of description as to where we are. But the light at the end of the tunnel has normally been a sort of wrongful trading type of description.
Yeah.
So because shareholders have that interest, therefore, and it continues right up until these times, therefore the creditor interest duty doesn't arise until later. That's essentially it. Lady Arden also thought that there was a sort of disconnect between the creditor's interests and where the control in the company lay. The control remained with shareholders, and she sort of regarded the duty as sort of redressing an imbalance or a disconnect between the interests and the control of the company. And that's a difficult analysis, I think, that nobody else subscribed to. Anyway, so all of them were able to agree on this reformulation of imminent insolvency or probability of insolvent liquidation. But as David, you've said, although it's dialed back the duty, does it actually make it any easier to apply? I mean, the imminent, I don't know what you think, but imminent insolvency, which is what the previous Supreme Court case had referred to, that's at least relatively well understood, isn't it?
It is, and I think you can get to grips with that and understand what that means, even if often you can't really express it in words. I think it's a convenient way of putting it. Probable, I think, is difficult because the directors might not know it's probable in time to avoid having unwittingly breached the creditor's duty. And I think that's going to be something that gets worked out in subsequent cases when claims are brought against directors. I'm sure they will be. I think it's a benefit to directors to have pushed the trigger date back. I'm not sure it's perhaps as straightforward as the Supreme Court might think it is in practice when we all come to apply this. Shall we just quickly move on to scope or content? Yeah. We've only got a few minutes left.
Yeah.
This is the question really about the balancing exercise between shareholders' interests and creditors' interests. The court agreed that where an insolvent liquidation or administration is inevitable, creditors' interests become paramount. And the reason for that is that the shareholders cease to have any valuable interest in the company. So whilst they are treated as having a proprietary interest in the company whilst it's solvent, once it ceases to be solvent, their interest obviously comes to an end because there's going to be nothing for them and is replaced by the creditor's interest in having the insolvency properly administered and them taking their share of whatever's available to them under the insolvency regime. And that's fine, where you've got an insolvent liquidation or administration in fact or inevitable. The difficult question, seems to me, is where the company is bordering on insolvency, but the insolvent regime is not inevitable. And then I think directors are in a difficult position, because the court says that they have to balance the interests of shareholders against the interests of creditors. And this is where we get into questions about taking risky decisions that might help you trade out and return to solvency. And that was an example given, I think, by both Lord Hodge and Lady Arden as something directors should not do if the outcome of that risky decision potentially was to provoke the insolvent liquidation or administration. But there's now this sliding scale, which I think is a difference from what the Court of Appeal said, and the way Lord Justice David Richards had put it there. And so we start, as we're further away from the inevitable regime, with a balancing exercise. And as we approach the regime becoming inevitable or actually happening, then creditors' interests take increasing importance until they become paramount. Don't know, Chris, if you want to add anything to that.
Yeah, well, basically, you've got these three stages. First of all, the stage one, which is the period prior to the duty arising. Okay, most of the members of the court seem to agree that there was no obligation to take into account the creditor's interests at that stage. Lady Arden's take on it was slightly different. She seemed to think that the creditor's interests should be taken into account under section 172(1 as well, and all of them acknowledged that there are references there to suppliers, etc., whose interests are to be taken into account in that period. You then have stage two, where the creditor's interest duty has been triggered. And yes, I agree, there's now a sliding scale, or as Lord Briggs called it, a sort of more nuanced approach than the more rigid expression in the Court of Appeal. And I actually welcome that, because I think it reflects the reality. You can't lay down a hard and fast rule, a cliff edge for when how the duty is going to be applied. It must be fact sensitive. And I agree with David that the effect is that as the company approaches insolvency, a greater degree of weight and balance, is what Lord Briggs referred to in his judgment, should be applied in favour of creditors. And then you've got the third stage, which is after the 214 duty's been triggered. At that point, the director's duty is paramount. And that's really a reflection of Parliament's injunction in that provision. That stage, directors have to act in the interests of creditors. So we've got this sliding scale. And you know, because of the time, I think we probably move on. But I think personally, I welcome that more nuanced approach, which I think reflects the reality.
Yeah, I agree. Very quickly, we're sort of up to time. The court has put an emphasis now on the duty being owed to creditors as a body, and that I think is going to be another point that will be difficult, not impossible, but difficult to work out in practice, because the directors may be faced with the situations, they often are, that they have to rob Peter to pay Paul, and that's not dealt with in this decision as to what they ought to do. You might say that if they have to act in the interests of creditors as a body, then they can't do that, and they can't pay one creditor ahead of another whilst they're hoping that the company's fortunes will turn around, as we often see happening in these cases. That might mean that the shutters come down somewhat earlier than might otherwise have been the case, because if they have to act in the interest of creditors as a body, they realise that there simply isn't enough money to pay them, and they are at the point of insolvency, and they have to stop because the Section 214 time has come. Chris.
Yeah, I agree. This is the Court of Appeal. Sorry, I didn't really deal with this. The Supreme Court has raised it as an issue, but they haven't really addressed this properly. And I think this is a problem with the judgment, because it actually could give a false impression to directors that they don't need to consider the interests of important categories or individual creditors. In particular, Lord Reid, I should say the majority didn't really deal with this at all. It seemed to talk about creditors in general. But the minority did. Lord Reid said that the duty emphasised that it was a duty to creditors as a whole, because you could have conflicting interests of creditors, and the identity of the creditors constantly changed. But people shouldn't take from that that directors don't need to consider the position of individual creditors, it seems to me, or classes. And that's a danger, as I say, about this judgment. And it's a shame, particularly because there was a Supreme Court decision in New Zealand last year called Debut Holmes, which dealt with the robbing Peter to pay Paul principle. It's a shame that this just formed no part of the judgment at all. So that's all up for grabs, it seems to me, notwithstanding what was said by Lord Reid and also Lady Arden in this respect.
Thanks, Chris. We said we'd talk about practical implications. We're a bit over time, so I think all I'm going to say is that we pointed out some practical implications as we've gone along. The biggest one for me is that the guidance isn't as clear as it might have been hoped, and I think we've managed to illustrate that for you. Chris, anything before we wrap up?
Well, I mean, where do I get from this? I mean, yes, I welcome some clarity, the changing of the trigger date and the adoption of the sliding scale. Other than that, everything is obiter, everything is still up for grabs, and this is definitely going back to the Supreme Court, in the next 10 years. And, does it make it any easier for directors to understand their obligations? I'm not so convinced at the moment that they've achieved that objective.
Can I thank you all for joining us? We're slightly over time, but thank you for joining us this morning for our initial reactions. Do please join us on the 8th of November for our annual Restructuring and Insolvency Conference. Chris will be talking more about this, and we have a full programme of other talks for you that day. But apart from that, enjoy the rest of your day, and thanks again for joining us.
Thanks very much.
Bye now.